Generally, to establish a claim for intentional infliction of emotional distress, or IIED, a plaintiff must prove that the defendant intentionally or recklessly engaged in extreme and outrageous conduct, causing the plaintiff to suffer severe emotional distress. In the context of IIED, extreme and outrageous conduct is defined as conduct that exceeds all bounds of societal decency. In Zalnis v. Thoroughbred Datsun Car Company, the Colorado Court of Appeals considered whether a car dealership engaged in such conduct when dealing with a customer. In January of 1978, Christiane Zalnis purchased a car from Thoroughbred Datsun, a car dealership in Colorado Springs, Colorado. In making the purchase, Zalnis dealt with Linnie Cade, one of the dealership's salesmen. In addition, C.S. Trosper, the dealership's president, approved the transaction. In fact, Trosper knew Zalnis for years, was aware she witnessed her husband's suicide, and knew that she'd been in a fragile emotional state ever since. Several days after the sale, Trosper discovered that the calculations Cade used were wrong and that Cade had sold the car to Zalnis at a $1,000 loss. Trosper then told Cade to either demand more money from Zalnis, get the car back, or repay the difference out of his salary. Cade didn't follow Trosper's instructions. Instead, Mark Anthony, a sales employee at the dealership, called Zalnis to tell her to return the car because it was being recalled. But when Zalnis arrived, she refused to give the car up without a work order. Nevertheless, it was taken. While Zalnis was at the dealership, Anthony called her a French whore, screamed at her, grabbed her by the arm in a threatening manner, and threatened and intimidated her. Zalnis contacted her attorney, who then called Trosper and demanded that the dealership return the vehicle. During the call, Trosper accused Zalnis of sleeping with Cade. Eventually, the dealership returned the car. Subsequently, Zalnis sued Thoroughbred, Trosper, and Anthony in state district court for IIED and slander per se. In response, Thoroughbred and Trosper moved for partial summary judgment on the IIED claim, which the court granted. In granting the motion, the court determined that the conduct didn't amount to extreme and outrageous conduct under Colorado law. Zalnis appealed to the Colorado Court of Appeals.